meat and potatoes of today. Today's session is titled A Fresh Start, the Importance of Expungement and Sealing of Criminal Records. Want to make sure I get that right. Today you will learn about the differences between expungement and sealing and the various initiatives designed to help more people clear their records. Our presenter today is Cynthia Cornelius, Director of Programs at Cabrini Green Legal Aid. Cynthia herself is an alum, so you were amongst good company. You can see how great it is to take this experience here and turn it into a lifelong career. She also was an Equal Justice Works Fellow, which is another cool program we'll have a presentation about later in the summer. But if you're interested in postgrad fellowships, please attend that one. But also ask Cynthia a few questions about her experience, and I'm sure she'd be happy to give you some info about that. So she has spent her entire career working with individuals impacted by the criminal legal system. And so I think she's probably one of the most perfect people to talk about this important issue. So we are so grateful to have you today, Cynthia. So with that, we'll give a round of applause for our speaker.
Thank you. And since we have a fixed camera, I think I'll just come up here where you were. How about that? Hi, everybody. I am so pleased to be here. We got to get our screen up. There we go. Now, I don't want to stand in the way of those who are in the room, so I'm going to kind of stand to the side. How about that? Everybody can see? Okay. So again, thank you for this opportunity and for such a wonderful introduction, Arthur. I'll tell you a little bit more about me in a moment as part of our introductions. But first, I want to tell you a little bit more about Cabrini Green Legal Aid. So we started off in 1973 as a ministry of LaSalle Street Church. We're celebrating our 50th anniversary this year, and we'll try to get some information out to you guys about that. It'll be in October. So in 1973, LaSalle Street Church was within walking distance of the Cabrini Green Housing Project. And the members of that community wanted to reach out to the Cabrini Green community to provide services. One of the members of this congregation was named Chuck Hogren, and Chuck was a new law grad, newly licensed attorney who was focusing on real estate law, probates, wills, but newly minted lawyer. In 1973, he said I think his annual salary was like $5,000 a year. That was a good lawyer salary back then. So he was attending the church and volunteering to work with the children from the community of Cabrini Green. And once the children and sometimes their parents learned that he was a lawyer, they would usually ask for some help, right? Something that they needed in their community. Most often, the request was for defense law. And Chuck would explain, but that I'm not that kind of lawyer, sorry. The response is what prompted Chuck and then the pastor of LaSalle Street Church, Bill Leslie, to do something more. He said usually the response was something along the lines of, well, then what good are you? Right? And with a heart as big as Chuck Hogren's, you have to know that really stuck with him. And he pondered that question, like, well, what good am I? Am I really contributing to the world, doing the good that I could do if I can't help them and they need help? So he reached beyond himself, beyond what he thought his capabilities were. He learned criminal defense law and family law and housing law and anything else that the people in the community of Cabrini Green wanted. So initially we were like the law firm for the Cabrini Green residents. But over time we grew and began to serve outside of the Cabrini Green community to expand to all of Chicago, and then for some of our legal programs, all of Cook County. But for our records relief program, we started reaching statewide. CGLA was one of probably only 2 legal aid organizations in Chicago back when I first joined Cabrini Green Legal Aid in 2009, who was doing records work. The other was Chicago Legal Clinic. And we were both partnering together and representing individuals in court and handling clemency petitions. But CGLA began operating the expungement sealing help desk at the Daly Center on the 10th floor in 2005. So I joined in 2009, just 4 years after that. So at that time, we were pretty much the only organization that was handling thousands of these petitions every year. So we developed expertise in that, and I was able to be in on some of the ground floor work that we were doing as we went outside of Cook County and went up north to as far as Winnebago County and assisted Prairie State Legal Services in conducting community summits. We went down south to Champaign and helped Land of Lincoln get started there. Went as far south as Madison County in helping to expand relief services to those communities for criminal records relief. So we were essentially like the technical assistance, provided technical assistance and expertise to the other legal aids in the state. And that's sort of the reputation that we continue to have. So it is my pleasure to be here today to share with you what I have learned over these last few years. So a little bit about me. So as Arthur said, I have devoted, I would qualify this. He said, I've devoted my whole career to this. Well, only my legal career, because I was what I call a non-traditional law student. I didn't begin law school until I was in my mid-50s. I'll just leave it there for right now. And so I knew I wanted to do something related to criminal law. And when I got to Chicago, I researched the Pili website to find out the description of what the legal aids in this area did. And I loved the description that I read about Cabrini Green Legal Aid. So I started volunteering there. And the only volunteer opportunity that was available to me as a 1L was to work at the help desk under the supervision of the attorneys. You may hear the name Beth Johnson in your career. I say to everyone, I learned at the feet of the master. So Beth Johnson is really the master of this work. So I started volunteering at the help desk and just fell in love with this work. It gave me so much pleasure to be able to not only help people take the first steps to put their criminal records behind them through expungement or sealing, but even when I couldn't provide that relief because they were not eligible for various reasons that you will be learning about shortly, we were able to educate them about what they could do and when they could do it. And just being able to give them hope is in and of itself so fulfilling. So I have continued that work. And again, I am honored to be able to share my knowledge with you today. I will encourage you as we go through this presentation, if you have questions, please raise your hand if you're here and put it in the chat box if you are not, and I will get that question, right? Okay, so what are these? Let's go back. I call these extrajudicial punishments, okay? You may also hear the term permanent punishments. You may also hear collateral consequences. All of these are just ways of expressing the reality of the way that our criminal legal system and our society works, in that even after a person has served a sentence that was imposed upon them by the court, they continue to encounter sometimes insurmountable barriers as they're trying to restore their lives and get back on track. And it's because of laws, actual laws that are on the books that prevent them from going into their desired field of study or field of work. Policies, internal policies within organizations. And so beyond the sentence that was imposed upon them for the crime that they were convicted of, there are more punishments. So the term I like is extrajudicial. Collateral consequences, to me, I don't favor that term because a collateral consequence may, sort of suggest that this is something you ought to expect to happen, right? Who would expect that after you have done what you were told to do, that you would still be punished decades later for a crime, having to explain it over and over and over again every time you try to take a step, okay? So this is the way our nation was started. This aspect of extrajudicial punishment goes as far back as the colonial days, when what was brought over from England was part of the common law, an aspect called civil death. So if you had some sort of conviction, you were going to lose some rights, period, the end, gone, right? And soon that was manifesting itself in our criminal legal system to be attached to felony convictions. Now, felony convictions are, of course, the more severe. Here in Illinois, a felony is defined as a crime that carries a possible sentence of imprisonment in state prison for a year or more. If the sentence is less than a year, 364 days or less, that sentence of incarceration would be handled in the county jail, okay? So it's the difference between prison and jail. So this concept of extrajudicial punishment has been with us since our founding. And it continues to manifest. I think, Arthur, will you be able to send them a PDF of this? Okay, so when you get this, you'll have the links for all of the slides that you're going to be seeing today if you want to do some further research. This graph comes from the Sentencing Project. And they've been tracking incarceration rates for quite a while. I think it's back from the 20s. And notice around the 80s, there's this precipitous increase in incarcerations. That was triggered by what you've probably heard about is the war on drugs, right? So when the war on drugs happened, it was a war not only against people who might have been illegally selling drugs, manufacturing and delivering the drugs. It was also against the people who were using drugs and had become physically dependent on those drugs. And so you see this precipitous climb of incarceration rates. It peaks out somewhere around 2010, but thankfully you see it's kind of declining a little bit. So let's hope that the work that we are all doing continues to make that trend go down. You'll see that there was the biggest drop around 2020. Any guess why? What happened in 2020? COVID, right? COVID happened in 2020, and it prompted many penal institutions to kind of let people out because they couldn't keep them safe inside because the virus was spreading so badly, right? So there was a big push to try to get people out if they could. And so that was a huge dip. And there's been just a little bit less since then, right? So let's hope that trend continues and you can be a part of it. Oh, let me go back here. Note the number. At its peak, we were exceeding 1.5 million people behind bars in cages. But that's not all. When people are released from prison, they're not immediately done with their sentence. Usually they have to serve a period of time under supervision. There are different names for it. Some states call it parole. Here in Illinois, we call it mandatory supervised release. Okay, but it's kind of the same thing. They're under watch. And then also, in lieu of being sentenced to prison, people are given probation, right? They're sentenced to probation, but under probation, they are still under the management and oversight of the court. So the Sentencing Project says that we've got about 3 million people that are using the colloquial term on paper. Okay, they are on paper. So when you take the 3 million and 1.5 million maxed out, that's like more than 1% of our population, right? That we've had either in prison or serving some sort of sentence in the community. Now, you know, again, you might say, well, if you do the crime, you do the time, right? But you also need to know, and you can get this information from the Sentencing Project as well, that about 97% of the time people do not go to trial, right? They do not go to trial. They will take a plea. And that doesn't always mean that they are taking the plea because they are avoiding some severe sentence that they would have gotten because they committed the crime. Sometimes they take the plea because they want to go home, because the potential outcome is just too big of a risk, right? Because there is a tax that's associated with it. If you don't take this plea and you are found guilty, you know, we're going to go for the max sentence, right? So that is our criminal legal system. And note that I call it criminal legal system, not necessarily criminal justice system. We need to do a little bit more work to get there. Another aspect of incarceration, and also these stats apply to people who are on probation and under supervision of the courts, is a racial disparity that you need to be aware of. Black men are incarcerated 6 times more likely than a white person. Latinos are incarcerated at a rate 2.5 times greater, right? And so again, if you commit the crime, you do the time, but it's not being equally dispensed. So keeping these things in mind, this is why the title of this presentation is, why is expungement and sealing important, right? I want you to understand why your attention to this situation is important as well. Has anybody read this book? Oh yeah, okay. It's hard when you're in law school to read anything other than what gets assigned to you, I know. So if you have the opportunity to take a class that's about this, you might be assigned this book, but read it if you can. It was copyrighted in 2010, so it's been around a while, but I will tell you that it is still very relevant to understanding why this work is important. The New Jim Crow is the name of the book by Michelle Alexander. It is chock full of data and fully researched information about how our criminal legal system has evolved to operate like Jim Crow laws operated in the South. And I will tell you, I grew up in Georgia. I was born in 1954, the year of Brown versus Board of Education, which you've learned about in con law, right? I was born that year, so now you can do the math. It was the height of Jim Crow in the South. What was Jim Crow? They were laws on the books. You've heard of Rosa Parks. She was arrested because she broke a law. She was not supposed to sit in the front of the bus by law. purely because she was Black. She broke that law and she was arrested. And you all know the rest of the story. The civil rights movement was born, right? And so for me, I lived that, right? My family and I rode in the back of the bus. We had to, when we went downtown to purchase items from the local department store, we had to enter from the back of the store. When we needed water, we couldn't drink from the refrigerated water fountain. It said white only, colored only. That was what we had to do. We go to catch Amtrak to visit our relatives in Chicago. And we would have to wait in the colored only waiting room versus the white only waiting room. And if you violated those rules, you could be arrested. That's the Jim Crow laws. So Michelle Alexander says, well, you know, we don't have those laws on the books anymore. And to a certain extent, we don't really talk about race out loud, or that some of our practices are racially motivated. We don't talk about that out loud anymore. But our system is still operating the same way. So once a person is labeled a felon or criminal, then there are other prohibitions and restrictions that are placed on them that still operate like Jim Crow did. It's a fascinating book. I encourage you to read it. And as you do, think about those graphs, right? All right, so now, why is this important? This is important because no matter what area of law you are focusing on right now in your internship, you will probably encounter someone who has a criminal record, right? Even if that's not what they showed up for to get your help with. But so I want you to know that. And within your organizations, there's probably somebody there that is doing criminal records work, because since over the years, since we began reaching out and helping people learn this area of law, most legal aid organizations now have some records practice in it. So seek those people out if you do have someone there. But here it shows up in employment issues, right? When are background checks run, right? And how are employers using background checks? It shows up in housing. Landlords, private and public landlords, all do background checks, right? So the record will show up there. Parental rights can be impacted. How many of you are doing family law? Nobody doing family law? Okay, all right. You will still be interested to know that a person who has been convicted of 3 felonies, doesn't matter what the nature of the felonies were, doesn't have to be violent, any felony. It could be retail theft. It could be felony damage to property, which is like painting graffiti on a government building, right? If you got 3 convictions in Illinois, then you fit one of the criteria of being an unfit parent. And under Illinois law, it's called depravity. So you could be considered depraved if you have 3 felonies. And if there is an issue involving your parental rights, it could be used to terminate your parental rights just by virtue of having 3 felonies. Shows up sometimes in voting and jury service, depending on what state you're in. Fortunately, here in Illinois, people can vote as long as they are not incarcerated and serving a sentence. So here in Cook County Jail, there are a number of people who are awaiting trial. They are incarcerated, but they have not been found guilty and sentenced yet. They are simply waiting on their trial. They can vote. And you might hear about voting drives at the Cook County Jail because of that. So only if you're in prison and serving a sentence here in Illinois does that matter. Education. All kinds of institutions also do background checks. that, and could be making decisions based on what they see, making decisions and judgments, okay? Public benefits with certain convictions. A person is ineligible to receive certain types of benefits here in Illinois. Direct financial assistance can't be given to someone who has certain felony drug convictions. That's a leftover from the war on drugs, right? You get convicted for drugs, you can't, even though you need help, we're not giving it to you because you got a conviction for drugs, right? Even the Supplemental Nutrition Assistance Program, SNAP benefits, are if you violate your probation, you're no longer eligible to get food stamps, okay? So go eat what you can. Immigration, of course. A person who is not a citizen, they get a record, they could be deported, right? Or it could severely impact their ability to move through the process of getting citizenship or legal status, okay? And then criminal debt. When a person is convicted and sentenced, the judge usually also says, and there's a fine, and you are required to pay this fine of X thousand dollars, and then off you go to serve 10 years in prison. And that fine is still waiting for you when you get out, if you have not been able to earn enough money in prison to pay that fine. So it's a judgment that could come after you once you get out. So no wonder the burden feels so heavy, right? It is such a heavy burden that people who have records carry for so long. More information that you might want to research when you get your PDF. There is an organization called the National Reentry Resource Center. They keep track of these extrajudicial punishments state by state, and they have a catalog. So if you're interested, you can go to that website, type in the jurisdiction that you want. And once you do that, you can see immediately, Illinois has 1,416 consequences related to records. And then you can drill down a little further to see what some of them are. And these are links directly to the statutes. So as lawyers, incoming lawyers, you might want to explore, what does the law really say about these restrictions, okay? For example, here in Illinois, there is a statute regarding employment in the Park District. Did you hear that we have a shortage of lifeguards? Okay. Well, in Illinois, there's a background check that's required to work in a park district, which lifeguards have to work in park districts. And you can't work in a park district if you were convicted or if you were adjudicated delinquent of a drug conviction in the last 7 years. Okay. And you can't ever work in the park district if you were convicted of a Class X felony or a sex crime. A Class X felony is one that carries a possible sentence of 6 to 30 years in prison. Okay. All right. There are similar provisions for healthcare workers. If they have a disqualifying offense, they would have to obtain a healthcare worker waiver in order to work as a custodian in the kitchen or as a certified nursing assistant. School systems, obviously teachers, but also the cooks and the janitors. This law applies to. It also applies to volunteers. So a parent who has certain convictions cannot even volunteer at their school. Okay. Medical Practice Act, that covers doctors and other licensed medical professions like LPNs. They are also prohibited from working in their chosen profession for a period of 5 years if they have a conviction. And then even after that, it is an appeal process to get the license reinstated if it had been terminated, or to go through the licensing process, okay? So heavy burdens, this is why it's important. So now that you got a sense of why this is so important, now we'll get to the meat of what is criminal records relief, okay? Now, first you need to understand what is a criminal record. You will meet people who don't know that they have a criminal record. So we have to explain that. A criminal record can start with an arrest. That's what we usually think. It starts, the way it starts. Once a person is arrested and fingerprinted, they immediately have a record in the arresting agency's database. The arresting agencies are required in Illinois to report that arrest to the Illinois State Police, who records it in their database. Illinois State Police is required to report it to the FBI, who records it in their database. So immediately, as a person is arrested, they've got a record in 3 different databases. And even if they are released without being charged, which RWOC means, they still have a record. But you'll encounter people who said, oh, but I was let go. You know, they released me. They never did charge me. But this thing showed up on my background check. That's because a fingerprint-based background check will show this. And the prospective employer will want an explanation of what that was, okay? But then if they are charged in court, obviously now you've got a court record in circuit court, so you've got your 4th database now. And they are required, the court clerk is required to report the disposition of all criminal cases to the Illinois State Police, who reports to the FBI. Now, a person could also get a criminal record by a complaint being filed against them directly. They may not be arrested. It's just a complaint is filed. Sometimes this happens with felony cases, misdemeanor cases as well, but an example would be a grand jury indictment, okay? The person is summoned to court, to appear in court. They are arrested and arraigned then, okay? But they've got a case in court already, right? And even if that case is dismissed, they got a case in court. And the court reports to the ISP and the ISP reports to the FBI. So person's gonna have a record in at least 3 databases, possibly 4. Okay, so that's why it's important to expunge or seal these records if you have one. Now, once a person has a record, there are really only 2 outcomes. It's either gonna be a conviction or not a conviction. So a non-conviction, we think about, okay, case gets dismissed, obviously. The case, the arrest that results in a release without being charged, obviously, is not a conviction. But there are also, in Illinois, there are some special sentences that are given, usually for first-time offenses, that if the person satisfactorily completes the terms, it's not a conviction. And again, when you're working with clients, they may not know that they don't have a conviction because they got one of those special sentences. But they knew that they were found guilty. And so on their employment application, they may have answered yes to that question. Have you ever been convicted? Because they knew they were found guilty, but they don't. In Illinois, they could lawfully say no, they have no convictions. So that's why it's important. Education is important to help them understand, okay? So now a little bit more. So what is a conviction and non-conviction? So we've talked about the dismissals, the acquittals, release without being charged. Here are some of those special sentences that if a person satisfactorily completes them, they're not convictions. You will hear about supervision, special probation called 710, 1410. Those numbers are associated with the statute number that created this remedy, but it's just known. This is the way that the court refers to 710, 1410. Satisfactorily completed, not a conviction. Don't have to do anything more, okay? So there are several of those similar. Second chance probation, same thing. Satisfactorily completed, it's not a conviction. but you did have to get found guilty to even get the sentence, okay? This task probation operates a little bit differently. It is a conviction. However, if the person satisfactorily completes the terms, they can motion the court to vacate that conviction, and then it would be eligible as a non-conviction to move forward, okay? So just know that it's not a simple thing to say that a person, look at a person's record and see that they were found guilty to say that they have a conviction. They may not. We have to research that. A conviction, as you might suspect, it consists of several outcomes. If the person is sentenced to jail or prison, obviously that is a conviction. If they are sentenced to just what I call plain vanilla probation, not one of those special probations, they have a conviction. So you have to know specifically what kind of probation was it. Requires you to research the record. There's a sentence called conditional discharge that is also a conviction. Works kind of like probation, except they don't have to report in to a probation officer, but they do have to fulfill certain terms. Time considered served is a conviction. That happens when the person may spend the weekend in jail awaiting their court date on Monday morning, and things happen so quickly in a criminal case that they don't realize that what has happened is that they have pled guilty and the judge says time served. Well, because they've already been in jail for 2 days. That's what the judge would have sentenced them to. So now they have a conviction. So some folks think that they don't have a conviction because they were able to walk out of court that day. So you have to explain, no, this is what really happened, okay? And then what you can't see on this screen, because it's so low, is fines. There are city ordinance violations and county ordinance violations that rise to the level of a criminal offense. But usually those are the sentence for those where a person is found guilty is usually a monetary fine. So under Illinois law, that is a conviction. You would be surprised at some of the types of ordinance violations that are considered criminal in nature. Have you heard of drinking alcohol on the public way? That is a city ordinance violation. And it's not just drinking on the public way. Just have an open container standing outside of Wrigley Field on a bad day, you could get arrested because it's drinking alcohol on the public way, okay? There might be a fine associated with that. Might not get arrested, you might get a ticket. But you have to show up in court, and if you're fined, it is a conviction because that's a criminal in nature violation. Smoking on the CTA is criminal. Going through CTA door, passing between cars is a criminal violation in Chicago, okay? So pretty easy to get a record here. The reason it's important for you to know the difference between a non-conviction and a conviction is because that's what drives eligibility. You can only expunge non-convictions. If a person has a conviction, we have to determine if they can seal it, okay? So it's 2 remedies, and we have to determine what people are eligible for. So what's the difference, you might be asking? Well, it's who can see the record. An expunged record is completely erased for the most part. There is an exception. It's completely erased, even from the records of the arresting agency. A record that is fully expunged, the arresting agency is ordered to destroy that record. And sometimes they won't just destroy it, they will mail it back to the person. Like here are all the records we have. You can do with it what you want, right? We don't have it anymore. So if a person who has their record expunged all the way and they're stopped and the police do a name search, nothing comes up, okay? They have no more record of it. There is an exception. Those special probations I just mentioned to you, those are not destroyed by the arresting agency. They are marked as expunged, but they don't destroy them because they have to know, and the state's attorney has to know, that the person has already had that one chance probation. Okay, so we can't destroy that record. Other than that, they're gone. A sealed misdemeanor is removed from public view and no public or private entity can see it. Not even those that perform fingerprint-based background checks. That's a misdemeanor conviction that's been sealed. Law enforcement, on the other hand, can see a sealed record. Okay, always. They can always see a sealed record. Law enforcement includes the arresting agency and the state's attorney. Okay. Sealed felony records, public and private entities cannot see those, except there are some employers that are allowed by law to do a fingerprint-based background check, such as, anybody know any that do fingerprint-based background checks? Yeah.
Chicago Public Schools?
Absolutely, all public schools. Even to be a school driver, you're gonna be fingerprinted, right? Hospitals, nursing homes, daycare centers, right? CTA, Metra, PACE, all of those, TSA, all of those have to be fingerprint, right? Employers that are allowed to do fingerprint-based background checks could see a sealed felony. Even it's sealed, but they can see it. They will know that it's sealed because it is identified on the report as sealed, but they can still see it. And Illinois law allows them to consider it in their employment decisions. Okay? Questions? All right, so now you know what a record is. You understand about non-convictions and convictions, expungement and sealing. Now let's figure out who's eligible for it. Well, if we have a non-conviction, excluding supervisions, obviously eligible to be expunged. But supervisions, we have to look a little bit closer. What kind of supervision was that? If it was for DUI, reckless driving, or a sex offense that involved a minor, Illinois law will not allow it to be expunged. It must remain on the person's record. Okay? There is an exception for reckless driving. If the offense occurred before the person turned 25, they are eligible to expunge it after they turn 25. Reckless driving is not just driving fast or recklessly, but sometimes DUI is amended to be reckless driving, right? So that's why they've connected the two, but there is an exception for youthful offenders. All right, but all other non-convictions can be expunged or eligible to be expunged. As far as sealing, all misdemeanor and felony convictions, all of them are eligible to be sealed except 4 categories. 1, misdemeanor or felonies involving domestic battery or violations of orders of protection or violations of stalking no contact orders. Okay, cannot seal those convictions. Violations of the Humane Care for Animals Act. That involves like cruelty to animals, dog fighting, those kinds of convictions cannot be sealed. Sex crimes under Article 11 of the Criminal Code. That's sexual assault, sexual abuse, but not prostitution. Prostitution can be sealed. Okay, felony or misdemeanor prostitution. Also, misdemeanor public indecency can be sealed, but no other crime that's listed under that article can be sealed. Soliciting a prostitute cannot be sealed. Prostitution can. And then what you guys can't see in here, it's the last one, is driving on a suspended license and reckless driving again. So if you have a conviction, just like if you had a supervision for those, you can't seal it either. Okay, that's it. Those are the only 4 categories. Any surprises of what's not excluded for convictions?
I'm doing some of this work this summer, and I was telling some friends about it, and I was like, oh, well, there are some things that aren't eligible, and my friends immediately said, well, murder, obviously.
Mhm.
And I said, actually, no. But I know that's a surprise to me.
Yeah, that was a surprise, right? Yeah, murder is eligible to seal. Yeah, in fact, one of our attorneys got a murder conviction sealed just this past Tuesday. He had been convicted when he was 18, served 41 years, and he's now in his 60s. Yeah, it was quite emotional. All right. Now, even if a person is eligible to seal or expunge, hold on, there might be waiting periods. It gets complicated, y'all. So there is essentially not a waiting period for acquittals and dismissals, except there's a special little dismissal called stricken off the docket with leave to reinstate, abbreviated SOL. And what it means is the state has, maybe it involved the offense involved a complaining witness who didn't show up in court. So the state is unable to proceed with the case. But what they'll say to the judge is, Your Honor, we ask that it be stricken from the docket today, but we reserve the right to reinstate the case. We don't know where complaining witness is. We need to figure out what happened, right? So they could bring it back next week. They have up to 160 days in some cases to reinstate it. So if there is an SOL dismissal, we have to tell people, gotta wait until this time period passes before we can expunge it, okay? That supervision that we talked about, there's a 2-year waiting period. After the completion of the supervision, if it's eligible, you can file a petition in 2 years. For those special probations that I talked about, for the drugs, 17 and 1410, second chance probation, there's a 5-year wait. They are not convictions, but the law won't allow them to be expunged for 5 years. Okay, and then the last category of convictions that would be eligible for sealing, we have to wait 3 years from the last sentence the person served before we can seal any conviction on their record. And what that means is if they have more recent convictions, if they have convictions that are 20 years old, doesn't matter. We have to wait 3 years to seal every conviction that's on their record, okay? So when people find out that some minor offense like smoking on the CTA that resulted in a conviction for a $25 fine now keeps them from sealing this 25-year-old retail theft, they get really sad about that, okay? But that is the way the law works. And those serious offenses, like murder, arson, that are eligible to seal, they also carry a requirement that the person sign up for a public registry, and usually for about 10 years. So they cannot seal those records until that registry requirement has been fulfilled, okay? So the gentleman that got his record sealed on Tuesday, he had served his sentence, he had been on the registry for 10 years, and then he was now eligible. So it's a long time. All right. There is an exception to the waiting period. If the person obtains a vocational certificate or an educational certificate while they are serving their sentence and complete it before their sentence ends, the law does allow them to waive that waiting period and file to seal the conviction as soon as the sentence ends. So it's important, if you find someone who is currently on probation or currently on parole, we need to tell them, if you do not already have a certificate, go get one before you get discharged, because otherwise you're going to have to wait to move forward. But this is was added to be an incentive for people. Yes.
Just wondering, are there any exceptions to the exception for certain crimes or certain convictions?
Exception to the waiting periods,
To
or
this exception, so it's saying that the waiting period is waived if the individual earns GED, high school diploma, and is that for any type of conviction that they're
That
trying
is
to seal?
eligible. Mhm.
Okay.
Yeah, for murder, for arson, if they, if they only had, if they had not even graduated from high school and got their GED
Mhm.
while they were in prison, they're eligible as soon as they're done, right? And so what is a question though, is what the court allows as a vocational or educational certificate, okay? It usually has to be a program that is going to involve some amount of dedication for 6 weeks, a 6-week program or multi-year program is what they're usually looking for. CPR does not count. Okay, we've had people, I got the CPR certificate. Nope, that does not count. Okay, so it is, so that would be something that the attorney would need to argue about why this does qualify. Okay, and then just know that there are other barriers that are placed on people who have records. So even once you're eligible to move forward, if you have a conviction for a felony drug offense, you're going to have to attach a clean drug test to your petition to show the court that you are drug-free. Also, this applies to any of those special probations. Must attach a drug test to it, okay? Lots of challenges folks have to go through, right? All right, so to quickly, I don't know what the time is running into, but just quickly to tell you, that's not all that's available to folks. That's just your basic expungement and sealing. So also know that there are some other options available for cannabis cases. Since cannabis became legal in Illinois on June 25th, 2019, there are certain cannabis convictions that are now eligible to be vacated and expunged. Okay, so some of that has happened automatically already, but there are still a lot of class 4 felony convictions and even misdemeanor convictions for cannabis possession that have not been cleared. So you may run across those. There are some other options specifically for prostitution convictions. They can also be vacated and expunged. Prostitution no longer can be assigned as a felony offense in Illinois. But there is now a motion that was tailored after the cannabis that allows a person to have that conviction vacated and then expunged all at the same time. There are some special convictions for people who were convicted of aggravated unlawful use of a weapon prior to 2014. That law was declared unconstitutional in People v. Aguilar. And now, if they are trying to clear their record, they can have those vacated as well and then expunged. There's a special provisions for victims of trafficking. They are eligible for immediate sealing of records in court. And there's also an immediate sealing provision for any case, any criminal case that was dismissed from court. Immediate sealing is available. You guys have heard of Jussie Smollett, right? And you know what happened here, right? So you remember some brouhaha over the press was upset because they couldn't get to his record after his case was dismissed. It was because his attorneys had requested and got immediate sealing. And so there was this motion to unseal. So it got done. If the person is not eligible to expunge or seal their records, then there are some other remedies available too. They might be able to get a healthcare worker waiver, a certificate of good conduct, if it's been 2 years without any other convictions. A certificate of relief from disability applies to specific occupations that require licensing, like being a barber or a cosmetologist or a nail technician or a boxer. All of those, it's listed. And then the ultimate remedy is executive clemency from the governor. Juvenile records, just know this will be in your presentation. I know we're past time now, But juvenile records, there are some juvenile records that are automatically expunged. Okay, I wish I could say that there's some technology that rips through the database and just takes them out, but that ain't how it happens. It's a very paper-bound process requiring a judge to enter an order for the future. And that order will be granted if that person is shown not to have committed any other offenses during that time. So just know that there's some automatic provisions for juveniles. For if it doesn't qualify as an automatic expungement, then juvenile records would have to be petitioned to juvenile court, just like the adults. And if there was no court action, the case was dismissed, they were found not guilty, or they got that special supervision and satisfactorily completed it, the juvenile statute says that the judge shall grant. It is not up to the discretion of the court. Okay, but if otherwise, they have to wait 2 years, and then it is at the discretion of the court whether to grant the expungement of the juvenile record. Juvenile records are automatically sealed. Okay, they are automatically sealed. This gets them destroyed. Okay. All right, and then just know that it ain't over. Once you get the petition, you got to file it in court here in Cook County. You have to file it in one of the districts, wherever the arrest occurred. I think they're working on simplifying this, but right now, if a person was arrested in all 6 districts, they're going to have to file 6 separate petitions. Then they have to go to court, and there is a mandatory 2-month notice period, so nothing happens. And then during that time, the copies of the petition are sent to the state's attorney, the arresting agency, Illinois State Police, and the chief legal officer for the city or village where that person was arrested. All of those folks are parties to this. They can all object. They can all object. Usually we only hear from the state's attorney. But if an objection is filed, then the person has to appear in court. If not, usually the order is just signed by the judge and mailed to them. And how long that depends on how long it takes depends on the size of the docket. Unfortunately, here in Chicago, the wait is over a year. Really, to just let the process go, it's over a year. So this is not something quick. When somebody walks in and says, I need help with my record, it ain't gonna happen in 2 weeks, okay? And then after it's granted, it still takes some time. The state's attorney's objections are based on different things. These are just some of the categories that we hear about in Cook County as the basis of their objection. Sometimes they don't object. Sometimes they object because they don't see the drug test or it wasn't provided. Sometimes they object if the person filed a conviction to be expunged. Obviously, that's not eligible, so they will have a statutory objection to that. Usually can correct that just by putting it on the right kind of petition. But the public policy objections are the ones where they just state it's in the public interest to have access to this record. And then it's the burden of the petitioner to say why their interest should outweigh the public interest in knowing about this record. Okay. The judge has complete discretion to grant or deny, complete discretion. And so it becomes an advocacy in court on the behalf of the person representing the individual to demonstrate to the court that they are deserving of getting this record removed from public view. And once they do that, then if a background check company searches for the record in the court system, they don't see anything. Nothing shows up, shows no record found. If, as I said before, fingerprint-based background check, nothing shows up unless it was a felony conviction, okay? So it does then pretty much relieve that burden. So finishing up, I want to leave you with a quote from John Lewis. It says, freedom is not a state, it is an act. It's not some enchanted garden perched high on a distant plateau where we can finally sit down and rest. Freedom is a continuous action we all must take, and each generation must do its part to create an even more fair, more just society. So I want to leave you with those words, because no matter what area of law you're in, if you're going to be in criminal law, you're going to be a defender, you need to know about this stuff. If you're going to be a state's attorney, a prosecutor, you need to know about this, okay? If you're going to be in corporate law, you still need to know about it. You might be in the employment section, you know? How are you helping to frame your company's employment practices with what you know, right? So no matter what area of law you're thinking of focusing on, I think this is going to be helpful for you to know how to do your part to help us overcome some of the terrible elements of the criminal legal system that are keeping so many of our fellow Americans back. Okay, thank you for your patience.
Okay, thank you so much, Cynthia. This was a wonderful presentation. As you can see, there's a lot that happens with it. So I will be sending this out as a PDF so that way you can reference it. And as Cynthia mentioned, a lot of the legal aid organizations have gotten grant money to take on this program and sort of offer this as a collateral service. So if you are interested, please inquire with your host agencies. At this point, for those in the room, if you don't have a paper survey, please get one from either me or my colleague Jack. Please take a few minutes to fill that out online. There's a link for the survey to fill out. Please let us know your thoughts. There's a real important section there that says ideas for future seminars. I read those and I really do take those to heart because I need to know what are the issues that y'all want to see people talk about, and I like to try to deliver that for you. So with that, anyone in the room, fill those out on paper. Please take some food for the road. And with that, I'll leave y'all to it. And I'm here for any questions that you may have about this or anything else. All righty, thank y'all.
Thank you.